A man is walking ahead of you on the road, absent-mindedly, while you are casually following him. He is about 7 meters in front, and as he walks, his wallet falls to the ground, but he keeps going. You notice the wallet, pick it up, take it home and check it. Inside, there is a credit card, some cash, and a driver's license. Now, there are 3 possibilities. Either you call the wallet's owner and return it, you take it to the nearest police station, or you give it to a nearby shop or store owner where you found it. If you do none of these 3, what legal liability would apply to you?
There are 5 possible things you could do next. Keep the wallet for himself and do nothing. Use the cash or cards inside the wallet. Take the ID or other items from the wallet and use them for something else. Sell the wallet to someone. Later, if he cannot find the owner, consider it his own. Let's take a closer look at each of these 5 possibilities one by one. If the person decides to keep the wallet and makes no effort to return it, that can legally be considered theft. Most U.S. states categorize this under larceny by finding. The idea is simple. If you keep something you know belongs to someone else with no attempt to return it, you've deprived the owner of their property. In California, if the wallet's value is under $950, it's classified as petty theft, a misdemeanor punishable by up to 6 months in jail or a $1,000 fine. If the value exceeds that, it becomes grand theft, a felony, with penalties that can reach up to 3 years in prison. In New York, the same act is called petite larceny if the property value is below $1,000, punishable by up to 1 year in jail. Higher values lead to grand larceny with escalating penalties. In Texas, punishment is based on the item's value. Under $100 is a fine up to $500. $100 to $750 can lead to 180 days in jail, and larger amounts can mean up to 1 year or more behind bars.
If the finder decides to spend the cash or use the cards, this crosses a much more serious line. Spending the money can still count as theft, but using the cards adds fraud and identity theft to the list. Federal law, under 18 U.S.C. Section 1029, makes it a crime to use someone else's credit or debit card without permission, even once. This can lead to up to 10 to 15 years in federal prison, depending on the case. If identity details are used, like a name, social security number, or card number, then 18 U.S.C. 1028 and 1028A apply, covering identity theft and aggravated identity theft. Even at the state level, using stolen cards is a serious offense. In New York and California, it's treated as fraud and can carry multi-year prison sentences, plus restitution, repayment to the victim for all financial losses. If someone removes the ID card, driver's license, or any other document and uses it, even for something as small as showing false identity, that's a federal crime. Under 18 U.S.C. Section 1028, misuse of identification documents can result in up to 15 years in prison depending on how the ID was used. Using it for financial gain or to commit another crime makes the sentence more severe. At the state level, possessing or using someone else's ID without consent is criminalized under local identity theft and forgery laws. Even if no money was stolen, the act of using another person's identity is enough for prosecution. If the finder sells the wallet, perhaps online or to a pawn shop, it becomes receiving and disposing of stolen property. The logic is clear. You can't sell something that isn't yours. State laws treat this as theft or trafficking of stolen property. If the wallet includes cards or IDs, federal laws under Section 1029, trafficking access devices, may also apply. In most states, selling found property knowingly can bring the same punishment as theft, fines, jail, and a permanent criminal record. This situation may seem harmless, but it's legally risky. In some states, you can claim unclaimed property only if you followed the correct process, usually reporting the item to the police and waiting through a legal holding period. If the finder never reports the wallet and just keeps it after time passes, it's still considered unlawful appropriation. Many states, including California and Texas, have clear laws requiring the finder to notify authorities or turn in found property over a certain value. Only after a set waiting period, often 30 to 90 days, and if no one claims it, can the property legally become yours. Skipping this step makes it theft from the very beginning. Finding a lost wallet may seem like a small event, but in the eyes of the law, it can carry serious consequences. Every choice matters, and doing the right thing not only protects others, it protects you as well. If you found this video informative, don't forget to like, share, and subscribe for more real-life legal insights explained in a simple documentary style. Thanks for watching, and remember, honesty always pays off in the end.